Welcome to lecture number 8 in my video series of lectures on how to be an effective social justice advocate, learning practical tips from the experience of social justice advocates for disability rights. My name is David Lepofsky. I am a visiting professor of disability rights at the Faculty of Law at the University of Ottawa. Today, I want to talk specifically about dealing with legislative bodies like a parliament or legislature. Also could be a municipal legislative body like a city council. How to do this is less obvious than you may think. Step one in doing advocacy in this area is you have to learn the process that legislation takes to go through a legislative body, whether a provincial legislature or our parliament in Ottawa here in Canada, or a municipal council. There's both a formal process, what are the formal rules, and of course, learning the informal process, the non-legislative steps or stumbling blocks that you can learn along the way. If a bill is going through a legislature, like the Ontario legislature, here are the basic steps. First, it has to be introduced for first reading. No, it's not actually read, but somebody, a member of the government, must introduce it, or an opposition member if it's a private member's bill. More on private members' bills later. At first reading, the politician introducing it makes a brief little speech about what it is and what it's for. There's no debate, and it's always approved on first reading, pretty much unanimously. There's no real debate. It's just a formality to get it started. The second step in the legislative process is for the bill to come forward for a second reading debate. This is where the legislature is to decide whether it approves the bill in principle. The government will decide which bills come forward. That's a whole process that I still don't quite understand. But they will list and schedule that second reading will take place. Not the actual vote first, but just the debate. There will be time for the parties to make speeches about it. That time can be unlimited unless the legislature, typically the government, passes a motion that dictates how much time will be allowed for each party to speak at each stage. That's called a closure motion. And that's something that a government decides on, especially if they have a majority in the legislature and they can unilaterally impose it, even if the opposition don't like it. At the end of the second reading debates is a second reading vote. Presumably, if it's a government bill, the government will vote for it. The opposition parties may or may not, depending on whether they agree with the principle in the law. And if it's on a topic that matters to your community, lobbying them about whether they should vote for or against it, or they may want to know. Second reading debate is a good time to find out where the parties generally stand. At the end of that, the legislature can decide to refer the bill to a standing committee for hearings or for clause-by-clause debate. They just say, we're referring it for study. That means the bill will be sent to a committee made up of members of all the parties. If it's a majority government, the government has a majority on the committee, and the opposition parties can have seats, but not enough to defeat the government. That committee will then decide whether it wants to hold hearings on the bill. They don't have to. They can hold hearings, at which point members of the public would have the opportunity to come and make statements about them. My next lecture is all going to be all about how to take part in those hearings. I've done any number of them. And after they hear from the public, from the community groups that they choose to hear from, the committee will then engage in what's called clause-by-clause debate. That's where they go through the bill and vote on it one clause at a time, one provision at a time. And while they're doing that, members on either side can move amendments. Now, if it's a majority government, an amendment isn't going to pass unless the government supports that amendment. But more about that too later. If it's a minority government, the opposition parties could actually impose an amendment that the government doesn't like, though that's not often the case. After the committee has finished debating the bill and doing clause-by-clause debate, the committee reports the bill back to the legislature as amended. So it comes back with any amendments that are made. The legislature can then agree on conduct third reading debates. That's when they debate one more time. All the parties get a chance to speak. If there's a closure motion, that can dictate how much time they have. And depending on the government, they may just not make it very brief. A closure motion can also regulate whether there's a committee, whether it will hold hearings, how long there'll be for clause-by-clause debate. Sometimes the clause-by-clause debate is made so brief that there isn't really time to actually debate much. Then after the third reading debate, the bill will go to a final vote. And if it's passed, it is a bill that is passed, but it becomes a law, but it is not necessarily enforced. If the bill will include a provision about when it comes into force. It might come into force immediately on being passed, or on a date that it specifies, or it can provide that this bill comes into force on a date to be set, or when it is proclaimed in force by the cabinet, called in Ontario the Lieutenant Governor in Council. So those are the formal steps. If the bill goes through our federal parliament, all of those steps happen, but to go through first through the House of Commons. But then after it's finished at the House of Commons, it's not done. It can't be proclaimed. It's actually not a law, because we have an upper chamber of the House. The lower house chamber is the House of Commons. It's democratically elected. The upper chamber, the Senate, is made up of members who are appointed to their position and don't have to ever be elected. A bill must be passed, a federal bill must be passed by both the House of Commons and the Senate in identical wording. Once the House of Commons finishes passing it, it can be transmitted to the Senate. The Senate goes through the same, or can go through the same process: first reading, second reading, possibly a committee with hearings, then clause-by-clause debate, and then back to the full Senate for third reading. If it is then passed in identical terms, then it's a law that comes into force when it says it does, whether it's immediately, if the law says it, or on, as I said before, when cabinet proclaims it in force, or on some future date. What happens if the Senate makes an amendment to the bill that the House of Commons did not previously pass? Well, then the bill can't become law when the Senate is done with it, because, as I said, it has to be passed in identical terms by both the House of Commons and the Senate. So the bill would then be, if the Senate has made any amendments, is reported out back to the House of Commons. The House of Commons, the government can then call it for a vote. It would only be voted on once to ratify the Senate amendments. And if the government has a majority and they call it for a vote, if the government says, yes, we approve those amendments, they're passed. If a majority of the House of Commons doesn't ratify any particular Senate amendment, it's not passed. Well, let's say the House of Commons doesn't ratify some, or indeed all, of the Senate amendments. Still not law, because it was passed by the House in its original form and the Senate in a different form. Well, our tradition is the House of Commons would then report the bill unamended by the Senate amendments back to the Senate. The Senate will then look at it again, and by Senate tradition, because they are not elected, will respect democracy and will approve the bill as initially passed by the House of Commons without Senate amendments. Those are the steps formally. If it's a municipality, we don't follow any of these. A municipal law is called a bylaw. It's presented to the city council. Often it doesn't have political parties, typically, and a majority vote passes it. Often these aren't passed unless it's you, or I shouldn't say often not. At times, if something comes up in city council, it's brought before a committee first to be considered. The committee can study it, can recommend that it be passed. It can ask the staff of the city to make a report, can go back and forth, but ultimately it comes from the committee up to city council, and then city council can vote to approve it or not approve it. The city council as a whole typically does not invite people to present. They call them delegations, but a city committee can, and you can apply by simply asking to speak to an agenda item that the committee has. You can't speak to a committee of the city council unless it is on an agenda item that they have set. This can be tricky because they often announce their agendas just a few days before their actual meeting, and so on. Now, let me turn from this formal process. Obviously, the government in power has a lot of control over what can be done. Let me turn for a moment to what a backbench member, of the government can do. If they're not a minister, they might, they're not, ministers typically introduce bills. What a backbench member on the government side could do, someone who's in their party, elected to the legislature or House of Commons, but not actually a cabinet minister, there's several things they can do, and why it's actually good to reach out to them. For one thing, they can do quiet internal advocacy. If they agree with what you're seeking, especially if you live in their riding, they can get to work trying to go to the minister, trying to find a solution, even going to the premier, whatever. And the fact is, they've got an avenue that we don't have, which is that they sit on the floor of the legislature, not physically on the floor. They sit on a chair on the floor of the legislature, but they can literally walk over to the minister or walk over to the premier and have a chat with them, which may be an avenue of communication that you otherwise have no way of getting anywhere near, and it can be helpful. The other thing a backbench member of the government can do, beyond lobbying internally for the cause, if they help, if it matters, is if they're supportive of what you're doing, is they can give you information about what's going on. I have had backbench members of governments talk to me and just let me know kind of some of the back room, what's going on, or what we may be up against, or whatever. I take everything I hear and try to verify it. I don't assume it's all correct, but I don't assume it's all incorrect. You have to take all that information and kind of keep it in your mind as you're undertaking this advocacy. What can an opposition party do for you, especially if it's in a majority government situation where they can't vote to amend a bill? Well, there's several things. One is, under the British parliamentary tradition, both in the House of Commons in Ottawa and in a provincial legislature like in Toronto, we have a daily procedure called question period, where members of the House, both government and opposition, can ask questions of ministers. And it's been kind of theater. It's become kind of theater. It's televised. Journalists cover it more than anything other part of the day. They could ask questions in question period. I'm going to talk more about question period in a couple of minutes. They can also, if they're in the opposition, also do informal lobbying, whether it's walking over and chatting with the minister directly, or others in the legislature, and possibly see if they can make some progress for you. And that's not unheard of, even though it's not highly visible. They can bring forward a legislative resolution, like I've talked about in a prior lecture, or a private member's bill, which I'll talk about again more in a minute. A private party can. Another important thing opposition members can do is they can make statements in the legislature. It may not be a question period, but there's a period called member statements, and they can make a statement. You might think it's just uninfluential and so on, but it could be a way that you get some issue aired, made public. You get the video, you can circulate it to the media and to your supporters and so on. Opposition members and opposition parties can write letters to a government ministry demanding action, to a minister. They can do a news release or news conference. And another huge thing they can do is, and this is, believe me, it's rare. I think I've succeeded in getting this once, but I think I only tried once. Opposition members are entitled to opposition parties are entitled to a limited number of what are called opposition days, where they pick a period of time is designated in the legislature, and the opposition party designates the topic. If they can designate a topic that is on the issue you're presenting, that is very valuable. It is certainly not something that happens often. The second last thing that an opposition party can do is they can organize their own opposition public hearings. This is not it's not done every day, but it's not an unusual tactic. If the opposition party thinks there's an issue that would be appealing to the public and important to the public, and that they can make some hay out of the government not listening, they can go and organize their own hearings where they invite people to a town hall meeting to share their concerns. The Liberal Party of Ontario did this in 1999. The critic on the Disabilities Act portfolio back then was a fellow named Steve Peters. And we approached them to do shadow hearings, and the party agreed to do it. So they sent him out. He went to, 13 or 14 or 15 different towns throughout a very cold February and March in Ontario. And from one community to the next, he held these open forums and just heard from people, and then released a report on what he found. The report was released at a news conference that I was invited to be at, and the opposition leader, his leader, Dalton McGuinty, who later went on to be premier, spoke at as well. This is all very helpful, especially if you're trying to build support for an issue that if the government doesn't deal with it, another party might deal with it should they be elected. Again, in the spirit of nonpartisanship. The last thing I want to say about what an opposition party can do is they can, through all of these measures, help ramp up pressure that something is a priority. The media are, as I talked about in an earlier lecture about the election process, the media are watching the various political parties to see what they think are the big priorities are. They're watching what the government says, and they're watching what the opposition says. If the opposition decides an issue is very important and is hammering it through these different mechanisms that I've just listed, that ramps up the likelihood of getting media coverage. If the opposition doesn't, then that's a signal to the media, and you may see less media coverage. I'll be covering media coverage later. As well, the government is watching to see what the opposition is prioritizing. If they see that a community group is pushing on an issue, but the opposition parties aren't even stepping up to the plate on it, that may make the government feel, well, I don't have to worry about this one because even the opposition aren't pushing it, and if we do nothing, we're not likely to catch any flack for it from the opposition. Now, let me talk for a minute before I get back to the overall legislative process. If you're dealing with an opposition party, who do you approach? In a government, you're going to be approaching members of the legislature, but also the minister who is directly responsible is going to have lead responsibility for it. And last lecture talked about steps for dealing with that. But when you're dealing with the opposition, it's kind of a different story. If your member of the legislature is in an opposition party, that's obviously a great gateway to getting in, because members of the legislature or parliament are and their staffs are most immediately responsive to people who are in their own riding. And you should know that they usually have two offices, one in your constituency or riding, and one at the legislature or the House of Commons, if it's federal. If you are dealing with, particularly with legislative policy matters, you may want to deal with their legislative office more, because they're going to be dealing more with the specifics of the bills that are coming through, depending on, of course, how much staff they have. There's another place to approach within an opposition party that can be very important. Opposition parties, if they're formally recognized, if they have enough members to be recognized as a party in the legislature or in the House of Commons, they'll have a research office. In the Ontario legislature, the Liberal Party and the New Democratic Party, at the time I'm recording this, are both opposition parties. There's a Liberal research office, there's an NDP research office. They will be staffed by people who are doing, they're not deciding policy, but they're doing the heavy lifting research. And so if you want to advocate with one of those parties, or get one of those parties to be pushing, let's say, an education issue, you may well want to find out who within the research office is dealing with education and talk to them about possible ideas. They will connect you unquestionably with the opposition critic who is responsible. Each opposition party has a critic assigned to be the counterpart to the minister. They call it a shadow cabinet, in fact. So if it's education, I might work with the education critic and work with the party's research office. In some part, it depends on whose staff are more easy to reach and with whom you have the longest working relationship. Sometimes you're working with both. You're not playing one off against the other, but it really depends on the informal lines of authority within the party, who's actually carrying the weight on a particular issue. Now, let me turn to question period. Question period is, needless to say, staged on both sides. The government actually gets to ask themselves their own questions, and they're usually, hey, minister, tell me why we're doing a great job about something. That's not what we're dealing with. Opposition parties each get a number of questions. The official opposition, the party in the opposition's got the most members, gets more questions, it gets first crack, and there's some ratio, a formula for how many questions they get. The advantage of getting the opposition to ask a question is this. Number one, it shows the government that the opposition sees this as a priority. Number two, it can be a way to try to get some answers, even though in question period questions are regularly, the answers are not direct answers, but rather political statements about what a great job we're doing or lambasting the other side. But you never know, you can get answers. Sometimes an opposition member will bring a question about a problem or a barrier facing a particular constituent, and they'll reach out to the minister beforehand, say, I'm going to ask about this, to give them a chance to fix it, so that by the time they ask the question in question period, my question is for the minister, so-and-so in my writings facing this problem, and the minister gets to stand up and say, well, thank you for bringing it to my attention, and my staff have fixed it, and aren't we wonderful? And sometimes you get a solution that way. But from our point of view, question period questions are not only a way to signal to the media and others that something is a priority, including to the government, but sometimes it's a way to present a proposition and actually get a statement from the government. It may be a bad statement, it may be a problematic statement, it may be a good statement. The dramatic day when the Ontario Liberal Party agreed to do an education accessibility standard on December 5th of 2016 was in response to a question we planted with an opposition member. So there are times you actually get a positive response, and that's the pivotal moment. But also, if they give a response that's not helpful to your position or even hurtful to your position, you can then go to the media, give your response to their response, and use it as a focus. Draw on your political advocacy toolkit that we talked about a couple of lectures ago, and go to town and make use of it. So how do parties decide what questions to ask in question period? I've only got some intel on this. Let me tell you what I know. For one thing, they meet I believe, each day to decide. The caucus will meet. And they size up. They'll have more people in their caucus who want to ask questions, who are pushing for the issue that matters to them, than they have questions to ask. And they are judging what are the points that are hottest in the media, what are the points that are most of greatest concern to the public, what has been the greatest headline-grabbing scandal that they might want to focus on, as among other things. It's a political strategic exercise that I can't say I particularly understand and I've never witnessed. What you need to do, if you want a question to ask, is you need to go to the critic responsible for the file. If it's education, it's the education critic, and say and work with both the opposition members' staff and then with the opposition member to push them to see the importance, get them excited about asking the question, because they then have to advocate within the party to ask the question. You can also work with the opposition research office on that. The opposition party, there's kind of a dance between the media and the opposition parties in deciding what to ask, what to cover, very much like the dance between the political parties and the media over what are the three big issues in the party. The opposition parties are watching the media to see what's the big headline-grabbing topic to decide what they should emphasize in question period. The media, in turn, are watching question period, and if something has been ramped up as the top issue that they opened the question period with the opposition leader blasting the premier on, then the media are more likely to see that that's an important subject that they're going to cover. After question period, typically politicians from the legislature come out of the chamber, and there's a scrum with journalists with their cameras and so on, following up, asking for each of them to make statements or on the leading topics. So that's the dynamic that goes on. If I ask a member to ask a question, it's typical that I'll be told, we're trying, we're in the queue, and then maybe, hey, we've got a question tomorrow. I've even had them call me and say, I've got a question tomorrow when I haven't even been pushing them. The next step for them is to write the question. If you can help them by doing their work for them, that really helps. Now, first impulse, especially if you are as verbose as me, is you write something very long. But what I've learned is to ask them, or they've learned to impose on me, is, look, it better not be more than 45 words or whatever. And usually there's a question and a supplementary. So I find that drafting it to be as short as possible. They may use it, they may not use it, but best you can do. Then the answers, the question period will take place. You will get a video record of it if you go through the video, which is archived but also available in real time, that you can share. But you can also get the transcript of the parliamentary proceedings. It's called Hansard, Hansard, and it's usually up online within a day, maybe even in a half day. And you can get that as quickly as possible. Usually, if a question is asked, I'll get an email from the member of the legislature asking it with a link to it right after, and they will do a news release about it. So there could be dramatic moments like Premier agrees to announce, to establish education accessibility standard, and you jump on immediately and do a media strategy or whatever. Maybe not. The other thing is the opposition, if they're going to ask a question about an issue, it's not unusual for them to ask if you can get supporters in the legislature while they're asking it. And the legislature has a lot of empty seats. They're often usually empty. Some are for the public, some are the government side, and some are the opposition side. That doesn't mean you're voting for the government or in a partisan way supporting it, but if an opposition member is going to ask a question period, they'll ask if you could have some people sitting there so they can point to you and do the kind of theatrics that you do in the legislature. You can also do creative things. Back when the Liberals were in opposition and Steve Peters was trying to push the then conservative Harris government to do more, The Supreme Court of Canada had decided the Eldridge case back in 1997, requiring that there be sign language interpreters provided in hospital emergency rooms. And 2 or 3 years later, there still weren't any. So he got up in question period and asked the Premier, when are you going to comply with the Eldridge case? Well, big deal, except he did it in sign language. He didn't say a word. He just stood up and said, my question's for the Premier, and then signed it. I think this was his idea, by the way. I'm certainly not claiming credit for it. But it's very dramatic. And then afterwards, his supplemental was to repeat it, because there was silence in the room. People didn't know what to do on the floor of the legislature. They didn't know what he was saying. It was very clever. Now, all of these speeches, second reading, your statements in the House, or question period, what possible value do they have for us? There's several. If they make a statement, whoever they are, it is extremely helpful as pinning the party down about their position. When the opposition Conservatives in 2016 asked Premier Wynne, why don't you have an education accessibility standard? And children with disabilities face too many barriers in school. Well, A, we got the yes out of the Premier, but B, we have that on record as something that the Conservatives said in 2006. And when they became government 2 years later, well, let's just say they haven't enacted anything over the very issue that they blasted the prior Liberal government. And so that statement made a decade ago can still have usefulness now. Let me talk to you about private members' bills. They have their use and they have their limitations. A private member's bill, typically introduced by an opposition member, but not exclusively, it could be a government backbench member, cannot spend money. They can only enact things that don't require allocation of money. There are either restrictions that you need to investigate to make sure a private member's bill is not going to get ruled out of order for some reason. They rarely get passed. In fact, they even rarely get past first reading to second reading or to a committee of the legislature for hearings. The government has to agree to it, and they typically simply don't. On the other hand, private members' bills can have significant benefits. For example, in 1994, when we had a new Democratic government in Ontario, new NDP government, the government had been asked by disability advocates in the community to introduce and pass a Disabilities Act, but it was very few people, kind of scattered, and the government didn't do anything about it. Well, then a backbench member of the government, Gary Lepofsky, who was totally deaf, and the first deaf member of a Western Democratic legislature anywhere, he brought in a private Ontarians with Disabilities Act bill. Now, the bill itself was nothing special, but that didn't matter. The fact is, it was introduced. We then lobbied as individuals, there was no movement yet, to get the government to agree to send it to second reading and then to a committee for hearings. The government decided, well, we can let hearings go. What the heck? An election was coming up, so it probably wouldn't get past that. So it might be performative, but what the heck? First day of the hearings rolled around on November 29th, 1994. It's a day I will remember forever, because what happened is about 20 of us went to the legislature to watch the first day, and there wasn't any presenters yet. The minister from the government was responsible for responding to the bill. And clearly she hadn't been given a mandate to say anything. So she made this speech that went on for, 20 minutes or whatever. And it was frankly really upsetting and angered everybody. She didn't speak to the issue. She didn't speak to the problem. She didn't speak to the bill. It was totally evasive. I was one of the people there. And about 20 of us who were there ended up storming down the hall. I don't know who set it up. I think Gary Lepofsky might have done this. But we all found out there was a room available, and we all went in to meet. And Gary got up. Remember, he's a member of the legislature. It's his bill. And he had a sign language interpreter with him. And he said to all of us, we got to start a movement. And it was right there that the Ontarians with Disabilities Act Committee was born. I didn't know at that time I was going to take on a leader role. That was weeks later. But the fact is, the couple of dozen people who were there, the 20 or so people who were there, they didn't plan to start a movement that day. They didn't start a movement that led to the bill. The bill led to the movement. So the most inconsequential or limited draft of a private member's bill that ends up going nowhere can still have huge long-standing significance. Private member's bill can also be a way of just catapulting an issue on the media agenda. Get it introduced, even if it's only for first reading, load the legislative parliamentary galleries for people to watch, and use this as a chance to get a public attention getter strategy. Now, what do I do when I'm dealing with political parties in these kind of settings? There's a couple of tips I want to give you. There's actually one, and it's absolutely essential. I take the position with each party that their position that they are going to present is not what they tell me behind closed doors. It's what they put in writing. And until they put their position in writing, I'm taking the position they're not taking a position. So I don't want anybody to say, hey, we're fully supportive of you and we know it's important, but it's not the time. And so my view is, till you commit in writing, in public, or in a public statement that we can videotape, there's no commitment. The second, and that's important because I want to avoid ever having a he said, or she said over what they committed or didn't commit. When I deal with any political party, the other major tip is I will talk to them internally about whatever I've heard within their party. I'll tell within their own tent. But I will not talk about what they discuss with me outside their party. So if an opposition member says, well, what's the minister said? Or if the minister says, well, what have the Liberals or the New Democrats or whatever, or the Greens said? My answer is, if you want to know their position, it's best for you to talk to them. My conversations with each party are confidential within the party. Now, that means I can talk to Minister A about what Minister B said and so on. That's part of the internal lobbying process, but I treat that as a 10. And again, they haven't asked me to agree to that. I've told them those are my rules. I recommend that. I think it's a very useful way to proceed. Whichever party I'm dealing with, I obviously have to be attuned to their political orientation and to tailor my advocacy to what's best to work for them and what they perceive to be their supportive base. But whoever I'm talking to, there is a universal term I use. I talk about voters with disabilities. Yes, I talk about people with disabilities and students with disabilities. But if I tell a politician in Ontario that there's over 1 million voters with disabilities in this province, probably a lot more, I'm inclined to think they kind of perk up because that's a lot of voters. Or if I talk about the disability vote. Now, if I'm dealing with the legislature, what steps do I take before a bill is introduced? There are several. Within my own community, an important step I've taken is to try to educate my community on the process for a bill going through legislature. I've been using all these terms clause by clause and second reading and closure motion. A lot of lay people don't know that jargon. So I have, on a couple of occasions, released an AODA update that provides a quick guide to how a law becomes a law. And I explain what I've just done early in this lecture in short but plain language. The other thing I'll do before a bill is introduced is I may well, if I know it's coming, is release an action kit. Talked about that a couple of lectures ago. that will be focused on the bill itself. In it, I'll say I can do things like identify what's our goal? What are we looking for in this bill? What are the key ingredients? What are the must-haves? And this will let people in advance be ready to think through what they're going to support or not. Now, I don't just pull these priorities out of the air. It's got to be really a product of the advocacy we've been doing all along through our feedback we've gathered and our common ground building and all that. It's not just something that's instantly invented. But I think it's really important for the government and the opposition parties and the media and our supporters to have a clear idea that if the bill includes A, B, and C, we'll think it's good. And if it doesn't have them, it's going to fall short. And so on. Once the bill gets introduced, well, on the day the bill's going to be introduced, there may be an opportunity to see it in advance. By parliamentary tradition, you're not allowed to, but sometimes what a government will do is before it's introduced, they'll do a lockup. So if you come to the legislature early, they literally put you in a room that's secured, offer you some incredibly lousy sandwiches, and let you review the bill. So then it goes in for first reading, and then you can deal with it and respond to it at that point. It's challenging, and I've been there, because with our accelerated news cycle that I'm going to talk about in a couple of lectures, the fact it is not unusual for the media to want an instant response. And you get handed a 30 or 40 page bill, and you got an hour to read it. And it's very hard to be ready with something. You don't want to just shoot off your mouth, because on reading it further, you may find out that what you said is inappropriate. So it can be a very intense hour, if you get a chance to take part in that lockup, to review it. But it helps having that short list of what the must-haves are in order to evaluate it, and that you can give to the media. Once the bill is debated in the legislature, second reading or anywhere, wherever, I try through, and an important strategy is to keep your supporters updated by getting the Hansard and posting it. If you've got the time and the energy, or people who can help, providing a summary of the highlights is also useful for people who don't want to read it all, but people do read it. That's one of the joys of democracy. Not everybody, but some do. If there are some serious and material misstatements that matter to you, a strategy is to release a fact check. And in a fact check, and I've done this both federally and provincially, if statements are made that we have to take exception to, I'll quote them and then give our response and explain why it's wrong. And if I can, give hyperlinks. And that might get sent to the media so that they're aware of it, but it also can be sent to the opposition parties if they're government statements, or the government if they're opposition statements, because they may use that in later parliamentary debates. It can happen that if you've got a good relationship with, if it's a government bill that you are supporting and that you're working with, or an opposition bill, or an opposition party who's trying to make it stronger, you may find they actually call you and say, hey, any suggestions that you'd like us to mention in our second or third reading speeches? Opposition, especially because they don't have the same resources as the government has to write those speeches, but it is an opportunity to actually try to shape what's said. Let me now talk about the process of securing amendments. This is if I could tell you that I really understand it all, I'd love it, but I'm constantly learning. If you are in the legislature in Ontario or the House of Commons, The standing committee will pass amendments that the government approves. So the actual decisions, the informal power power authority or line of authority, is not the people in the room, the members of the committee who are presented to debate and vote. It's actually the minister, or if it's the prime minister or premier's, whoever's, depending how sensitive it is, someone out there is really calling the shots. And the members of the committee from their party are frankly doing what they are told. I don't know to what extent. I've had some tell me, yeah, we've got some room to have a say, but you've got to really find the people who are really making the decisions. In an opposition party, it really will depend. In some parties and in some contexts, the party's leader's office really wants to be calling the shots, and sometimes it's the opposition critic. You got to have done your groundwork well before. If the bill is missing certain key things, you need to have come forward with a brief that lists the kind of amendments you want, so you're in a position to work with the committee before they ever meet to deal with them. Because while they debate in the meeting, it's actually pre-decided by each side what they're going to do with it. In the Senate, it's a very different situation. Senators are not elected. They don't have as rigid a party process. There are liberals, there are conservatives. There are a number who are called independent now. And even those who are party affiliated may not vote party line. When you're before a standing committee, and I've been twice, of a committee of the Senate, I find that each of the senators are, in many cases, not every case, a free actor. They can support or oppose something if they decide it's worthwhile. Therefore, it is vital in all cases to come up with your package of amendments early and be able to share it with them. You can't get every amendment passed that you ever wanted. There are strict rules. And some of the rules don't make any sense to me, but the chair of the committee may be advised by whoever, the clerk or whoever gives them advice, that a particular amendment is out of order. It may be very frustrating, but that is actually the case that you can run into this. Now, when you want an amendment made, whoever you get, especially if you're dealing with the opposition parties, if you send them what you want, you may not send it in legislative language, because writing that can be very tough. They will send it to the Office of Legislative Counsel. Legislative Counsel will then write the amendment in the terms that they think is legally permissible to fit it within the bill. I have had occasion to ask the opposition party to share those drafts with me. In Ontario, they've been prepared to in some cases. In Ottawa, I've run into more of an obstacle. Making this even worse, before the committee meets to actually debate amendments, they file motions for each amendment. In the Ontario context, they have been prepared to make them public. On our website, we get them, we post them. So before they ever sit down, we know what each party is proposing as amendments. In the case of the House of Commons, they had some bizarre rule last time I was there around 2022, which was that it would be somehow a violation of parliamentary privilege to release them anywhere, which makes no sense to me. So what you'll find is you watch the committee debate, and they'll say, we're considering motion number 12, amendment to section whatever, any debate. And we, watching, don't have a clue what the motion or the amendment is until it's voted on, and the Hansard comes out, and then the revised bill comes out after clause by clause. It's absurd, but that's what we sometimes can be up against. Let me talk about third reading for a minute. In third reading debates, it's technically possible to get an amendment to a bill, but it's very rare. Pretty much after the bill comes out of committee, that's what's going to happen on third reading. But third reading debates are a good place to try to get statements from parties that you can later quote, either what the government promises this bill will do, and even if you think it falls short, You can go back to them later and say, hey, you said this bill would do X in third reading, and it hasn't. So let's talk about that. In fact, we, after legislation's been passed where we think it didn't go far enough, will publish a list of statements the government said it would achieve. So later advocacy can build on that and say, hey, you said it would do X, it didn't, now we got to fix it. Let me talk to you now very briefly about going to the Senate. It is rare to get a chance to do that, but I've learned a lot about it. The Senate theoretically can amend a bill however they want, but in practice, senators, I have found, feel very much constrained. If they revise a bill too substantially so that it is a significant departure from the government's agenda, then they risk, it'll pass the Senate, it'll go back to the House will reject all their amendments, then it's going to come back to the Senate and they have to pass it as is without their amendments. That would be a waste of their time. So I have found senators who are looking for the sweet spot, an improvement that is helpful, but not so far-reaching that it will lead the government to reject it when it comes back. It is not a science, but there is this real nervousness. On top of that, what you find if you approach any senator, and I've talked to any number of them, they don't have a research office. They don't have a major source to do this thing. They each will have one or two staff, but they are busy being torn from one bill to the next to the next. So if you want to try to get the Senate to make changes, they will press you very quickly to keep the list short. What I'm finding, it's enormously frustrating, but what I'm finding you've got to do is you've got to look for, again, that sweet spot of proposals that, number one, are easy for them to understand. If you've got to spend a whole lot of time explaining it, and you've only got a half hour on the phone with them, or 10 minutes at a public hearing or something, you're going to gobble up all your time. It may be important, but you may lose the capacity for maximum gain. So it's got to be something you can explain quickly. It is preferable if it's an amendment that you can word in very clear language, in simple language, so that a senator who may well not be a lawyer, the same way members of the legislature or parliament may not be a lawyer, so that they can look at it and see the obvious appeal fairly quickly. And you want an amendment which not only a senator can see as attractive, but that they can also persuade some of their Senate colleagues to jump on. And finally, what you want are amendments that are, while helpful, of the kind that essentially back the House of Commons into supporting them. We had this when the Senate approved some amendments in 2019 to the proposed Accessible Canada Act. Nowhere near all of what we wanted, but we knew that the bill would come back to the House of Commons in June of that year, and that in July the House would rise for an election. So the government had two choices: either approve the Senate amendments or lose the bill entirely and have the disability community enraged that they didn't pass anything. They ended up passing the Senate amendments. They, in fact, passed amendments in the Senate to the Accessible Canada Act that the minister had vigorously opposed when the bill was in standing committees the fall before in the House of Commons. That is a strategic exercise that requires you to spend a lot of time talking to senators and seeing what you can manage to, what you could achieve. Let me finally turn to what happens after the bill is passed. Obviously, we work with it to try to see what we can get out of it, but in several bills that I've been involved in, the bill has included a requirement of a review 3, 4, 5 years afterwards. That provides an opportunity to come forward, point to amendments, point to how the bill hasn't lived up to its promise if it hasn't, point to amendments that you proposed 5 years ago that were then voted down, and say, hey, maybe it's time to reconsider these and see if you can get somewhere. Well, that's a quick ride through the legislative process. Next lecture, we're going to talk about the specifics of preparing and appearing before a parliamentary or legislative hearing. Catch you then.